Good afternoon, everyone. Thanks for joining us. I'm Russ Rivera, and for those of you who may have remembered me doing the Discuss with Rust kind of podcast video program, this is sort of a restart. But today I'm with Stella King, and we are going to be discussing powers of attorney and how you can avoid a lot of pitfalls in dealing with them. We'll go back to the beginning and establish who should have them and why and when, as well as a couple of stories we can talk about in order to, make your situation a little bit better wherever you might be. So, before we get started, I, of course, want to introduce our guest, Stella King. She is a partner at the law firm of Aeneas, Scanlon, and Cirinano, located in White Plains. She has a decade of experience and immense knowledge of New York elder and estate planning laws. She also provides guidance on a wide range of matters, including wills and trusts, powers of attorney, which we're going to be talking about today, estate and probate administration, guardianship proceedings, Medicaid and nursing home care planning, and special needs planning. So I've had the pleasure of having Stella help me out and some clients out as well. I'm happy to have her. She was also named to the 2025 Super Lawyers list in elder law and was a rising star in 2021, 22, and 23. She's obtained her JD from Hofstra in 2012 and was also admitted to practice in New Jersey in 2019. So with that, Stella, thanks for joining us this afternoon.
Thanks for having me.
So the primary purpose of today is really to help people figure out how they should use their power of attorney most effectively. And so first, why don't you start by telling us what a power of attorney is?
Sure. Well, a power of attorney is a very important legal document that you, the principal, execute during your lifetime while you have mental capacity, and where you designate another person called your agent to handle your financial affairs and personal affairs if there ever comes a time when you're unable to do so yourself.
I've also heard that agent be called an attorney. In fact, is that just more jargon, or is that just, what should we use today to
Power of
kind of?
attorney, in fact, they can be used interchangeably.
Very good. Again, and just so you know, we will have some room for questions later, so please keep yourself muted. Happy to be on or off screen, whatever you'd like. But we will, have you have the opportunity to ask questions later. And for compliance reasons, the chat has been disabled, so we are going to have to wait for later. I think you'll be able to put your hand up when we get there later. So, thank you for that on kind of what the power of attorney is. So, who should have one?
Every person, I would say every person, regardless of age, who is over the age of 18 should have a power of attorney. Because if you become ill or you suffer a tragic accident, and you don't have a power of attorney, or your power of attorney is not sufficient, then you won't be able to have your loved one take necessary actions on your behalf. And the only option may be a guardianship proceeding, which is something that you best want to avoid.
Yeah, I can certainly understand that. I mean, I know we'll get into that a little bit more later with some of the stories. But I think one of the questions is, right, a lot of people really don't touch upon doing some of those things until they're actually thinking about, the hereafter,
Right.
to use the term of phrase, right? When you say someone who's 18 should have one, why would essentially kids, at least to us,
Sure.
think about doing something like that? And in what circumstance would that really be an issue? I mean, is there like an income or assets reason to have it done? Something like that.
Well, for example, let's say that, a child is going off to college, and they have a bank account that's in their name alone, and the child gets sick or is in a coma, or there's something hooked up to their bank account. That's important. That needs to be addressed. Something happens to the child. Just because you are the child's parent doesn't give you access to their bank account. If that account is in their name alone, it's not able to be accessed unless the account owner has a power of attorney, a person under a power of attorney, and that agent under the power of attorney has the power to access that bank account.
So let's deal with how most people come into having one of these done, right? It's usually
Mhm.
part of the initial estate planning process, right? You go to see an attorney like yourself,
Mhm.
you have a will done, and then of course you would by nature put in the power of attorney documents and maybe a healthcare proxy or a living will or something like that.
Mhm.
Um, so that's all well and good. Now someone, forgetting whether they're young, they're old, they now have that done. um, what should they do with it once they actually sign it?
Well, I mean, it's important to remember that not all powers of attorney are created equal. So, people have powers of attorneys. Sometimes they draft them themselves, they draft them online, they get them from title companies. There's a lot that actually should go into a power of attorney. And if your power of attorney doesn't contain specific powers or isn't on the valid form, it's essentially meaningless. So I would say just having a power of attorney, it's not just check the box, that's it, I'm done. You would really want to take a good look at your power of attorney to make sure of certain items that are included in it.
So what should be in that document, right? Again, you kind of said it gives you power to do certain things, and I realize,
Hmm.
and I appreciate you bringing it up. There are so many different things you can
Sure.
empower someone to do, and things you can reserve. So please
Well,
tell me more.
the first thing is that you should always make sure that your power of attorney is not a springing power of attorney, meaning that your agent is authorized to act only after a specific event or condition occurs. This can be problematic because that event, what the occurrence of that event could be subject to interpretation. Your power of attorney should be effective the moment that you and your agent sign it. It's also very, very important to ensure that your power of attorney is durable, meaning that it survives your subsequent incapacity. So your agent should be able to act on your behalf even after you've become incapacitated and unable to manage your affairs. Also, your power of attorney shouldn't be limited to any one specific task. There are limited powers of attorney, but the power of attorney that I'm talking about would be a very broad power of attorney that would give your agent authority to act on your behalf in, all sorts of legal matters, financial transactions, real estate, signing contracts. And also very important, if your power of attorney doesn't expressly convey the ability to make gifts in unlimited amounts, then by default, your agent can only make gifts or transfer out of your name. I use that interchangeably up to $5,000 annually. And this is a vital power, Russ, because to be able to transfer money out of your name if something happens to you and your agent needs to pay your bills or get a home carried for you or do Medicaid planning, enroll you in a pool trust, or if you're wealthier, engage in estate tax planning. So that's extremely important. Um, Also, the power of attorney, you want to make sure it's up to date, that it's on the most updated New York statutory short form, which is from 2021, and that the power of attorney designates someone that you still trust completely as your primary agent, as well as alternate agents if those individuals can't act. And so, I mean, all of those things are very important. We see these DIY, do-it-yourself powers of attorney, and they may not be valid.
So I just, you mentioned something really important, and that's
Mhm.
the idea of trusting the person you're dealing with.
Mhm.
Um, And so, this kind of makes me wonder about, right, the downsides of actually having one. So why don't we address kind of the downsides of having it before we maybe go into some nuances?
Well,
or potential downsides, I should say.
Yeah, I mean, it's hard for me to say that there's a downside. But it is very important to appoint someone that you trust. If you don't appoint someone that you trust, then, you would be giving somebody a lot of power, the power to, run off with your money and do whatever they want. And they could abuse that power. So it is a scary thing. But I would say if you don't have someone in your life that you trust, there are individuals who are licensed and bonded and are willing to act as professional powers of attorney for those who don't have family members. And again, I personally think that's well worth it as opposed to something like guardianship, which, can be expensive, time consuming, and very difficult.
So yeah, and I think you mentioned right the major risk is right if it's somebody you don't trust or somebody you do trust and you fall out of trust, they now have the ability to basically do what they want with your finances. I mean, obviously that's going a long way to have to get there, but that is what I was kind of leaning towards. And you did mention some of the nuances. I know one of our guests here said they've had one for 20 years. And I know that in dealing with people who do what you do, the time to update a will is probably every 10 or so. You might have a different thing on that, and I'll be happy to hear that. But should your power of attorney document also be updated, and how should it, potentially be amended?
Well, I do think that it should definitely be revisited. I would say anytime that, you have a milestone in life, a divorce, a death, of a spouse, or you come into a lot of money, or you just bought a business. I mean, you want to look at your power of attorney to make sure that it contains the powers that are needed based upon your life situation as it stands, and B, that it's on the updated form so that it's valid. And the laws change as time goes on, so things can transpire that you want to make sure there's wording in your power of attorney to address. And also, relationships change. People have falling outs, they have arguments. The person that you appointed 5 years ago may not be someone that you would appoint now, or they may not be alive. Or your contingent agent might not be alive. So it's a good thing I'm not necessarily saying that it needs to be revised every 5 years, but I would say, it's a good thing to, pull it out, look at it frequently, make sure that it has all of what I described before, and make sure that it is, you know, um, it's still someone that you would want to act on your behalf.
Good. And so I think this comes down to the main question and the main point of me trying to do this is the question is to really how and when should one make it operative? I mean, it's one thing to have the document signed and put in your safe or put in your papers, but right, that in and of itself may make you think you have the right to act, someone else has the right to act on behalf, but do they really?
Well, that's a great question. I'm of the position that the power of attorney should be operative right away. So that it's ready if and when your agent needs to use it. Now, for example, I have a power of attorney. I appoint my spouse as my agent under my power of attorney. The power of attorney is affected. I've signed it. My agent, has signed it, but he doesn't just automatically have access to it. We keep a copy of it, at my office. And if I were to become incapacitated, or, he needed to do something for me, we have, separate financials. He would need to contact my office and provide them with, a letter from a doctor stating that I'm unable to handle my financial affairs before they would release it to him. So there are safeguards. You don't have to actually give your agent under a power of attorney, even though it's effective right away. You don't have to actually give it to them right away, but they should know where it's located, how to access it quickly. And, if you are nearing an age or a health situation where you think uh, your agent may need to act on your behalf now or in the near future, then you may want to consider, for example, you can add them as you can give a copy of your power of attorney to your banking institution and add that individual as POA to your account. Once you do that, though, they will have access.
And I think that's the question, right? Is when do you give it to the institution, right? So you and I discussed offline kind of the two events that made me think about this that I've seen in recent times. So one involves, so maybe I'll ask you, I'll put a little out there, we'll have a little discussion, and maybe you'll diagnose what maybe could have or should have been done differently. Um, so one involves an older woman. She has a health episode, and she ends up basically in nursing home care, not really able to take care of her affairs anymore. And now maybe the attorney maybe even the agent had the power of attorney document, but now the agent comes to the various financial institutions and says, okay, I want to do this. And the problem is right, the financial institution doesn't have the document. And now it's like, well, we can't do what you have until we've done what we have to do. And so you can't necessarily, as agent, act as quickly as possible. What are your thoughts around that?
Um, well, I mean, that can be both a problem and a safeguard. So, I mean, on the one hand, yes, that means that the bank would have to take their time and process the power of attorney and make sure that they find it acceptable, and that can take time, which can be a good thing if there's anything, unsavory going on, which does happen. Um, but if you're concerned about that lapse in time, then there are other things that you can think about. Like, as I was just saying, having the power of attorney be added to your account before, just in case. Or maybe making your agent under your power of attorney, make them a joint owner of the account. It doesn't work in all situations. It may not be, you may not feel comfortable with that because they'd have equal access to the account. However, it is, if it's a child or a spouse or a trusted friend, that person would automatically be able to step in and take action for you. Similarly, there are other vehicles that people use, such as a revocable trust, where a co-trustee or a successor trustee can step in and manage your assets. So there's other options that allow a quicker way to fulfill the task that you're trying to fill with the power of attorney. But the power of attorney also, you may not want a quicker action because of those safeguards.
Fair enough. And obviously moving to a trust is something you have to plan for in advance, and sometimes is a lot of excess cost compared to the others. So there are other factors to consider when you're doing that, right? Whether or not that's the right answer.
It is, but if you're, it's more on the front end, but it's also more preparation. Um, it's if you're talking about an easier way to, for somebody to step in and pay your bills and make sure that everything that gets done is able to get done. It is quicker in some ways, but it's not for everybody.
Sure, understood. Um, Very good. And then the second one I'm dealing with is where they did the right things and the power of attorney document had been filed. Um, but there was something unique about it. So let me take it back to the beginning. Husband and wife are married. Husband begins to have some cognitive, I'm sorry, wife begins to have some cognitive issues. Husband is the power of attorney, is the agent, as we would expect. I will use the wrong term liberally here when I say power of attorney. But agent, I'll try to focus on that. Um, so husband is the agent, and they have a successor agent who are their kids, who are to act jointly. And so this is one of those unique things where I've seen it before, where sometimes agents or when multiple agents are listed, they can either act independently or they can act jointly. In this particular case, as successor agents, they were able to act jointly, and their money was at a few different places. Yet one of them would not accept the document when they had to act jointly.
Mhm.
And so also there was questions now about mom's competence. So now they were basically telling them they were out of luck and needed to go to a court proceeding. Um, Thoughts there?
Yeah, so that's a great example. It is a big decision when if you are appointing co-agents under a power of attorney or co-successor agents as to whether you want them to act jointly. Again, you're sort of walking a tightrope between, on the one hand, having co-agents, making it so that they have to act together. One can't do something without the other signing off on it. It does provide a system of checks and balances. One kid can't go run off with the money and gamble it in Vegas. But not that we would hope that that wouldn't happen anyway, because they must act in the principal's best interest. But it does provide checks and balances. On the other hand, if you allow your agents to act separately, then if one, if there's an issue with one of your agents, or let's say that your kids are located on, opposite coasts, one's in California, one's in New York, it's going to be very hard logistically for both of them to be in the same place at the same time. And while technology allows, a lot of remote signing and that sort of thing, banks are different. Financial institutions have different policies and procedures, and you don't know what they may or may not require. So it's something that you really need to think very carefully about when appointing co-agents. Do your kids get along? Do they live nearby? Do you think that it would be a problem having them act together versus separately?
In your experience, how what kind of counseling do you give to a person or to a couple as to making these selections, making these suggestions? Because again, family structures are different. Some people may not have anyone anymore. What is that type? What is that when you're meeting with a client? What does that look like to you?
Well, it is different for every client. I would say that if there's any semblance of arguments among the kids, if they don't always get along, you're worried that they may not do so in the future, don't have them act as co-agents. Have one and then the other. Or maybe it's not a good idea to have your kids be your agent under your power of attorney. Maybe it's better to have a sibling or a friend, or maybe things are fine and you have them as co-agents now, but as life goes on and life changes, again, this is another reason why it's a good idea to revisit your power of attorney more often than, 10 years, or even 5 years if your situation changes. If your kids are the co-agents under your power of attorney and they have a huge falling out and are no longer speaking to each other, maybe you should redo your power of attorney to not have them act together.
Fair enough. Yeah, no, I also have a situation I could think of where a trust, where they had two kids who were cats and dogs, having to act together, and that created a lot of problems and cost both parties a lot of money.
Right.
Um, and that didn't work out very well. Um, so yeah, certainly. Um, at this point, I figure I've asked all of the questions that I have. Is there anything that I missed that you on this topic that you thought made sense to share?
Hmm. I mean, I can talk about the power of attorney forever, but I would say, I think that there's definitely, I'm glad that you invited me to do this today, because I do feel like there's not enough focus on it. There's always a lot of focus on the last will and testament. A power of attorney is so important because this is who's going to really take care of your affairs, take care of your money, everything. if something happens to you. So by making these choices, making sure that your power of attorney is valid, making sure that it has all the powers that your agent needs to do, making sure it's someone that you trust, making sure that they're successor agents, making sure that the power of attorney is broadly drafted, but includes powers that are tailored to your situation as well. That it really allows you to sit in the driver's seat should tragedy or disaster strike, because we don't have a crystal ball. We don't know what's going to happen in the future. This allows you to make a choice as to who you want to be in charge.
You actually made me ask one other question that I should have asked before, and maybe when we do the recording of this, we'll have it edited back to the right spot. But what are some of the things that you can appoint an agent to do or not do that in the document? Because if I've seen some of these, and again, some of them are like a statutory form, and some of them are very different, and so yeah, just give me an idea. So you could give them some powers, but not all. So give me an idea as to what that might
That's
look like.
true. So, I mean, you can give them the ability to, there's a modification section in the power of attorney. And the modification section, too often I see powers of attorney that have a very small modification section, or, there's nothing written in it. But the modification section is where you actually expand the authority to include, well, the ability to gift in excess of $5,000, and the ability to do other things that for example, adding beneficiaries to bank accounts that don't have them, enrolling you in a pooled trust, opening safe deposit box, accessing your digital assets, doing estate tax planning, hiring attorneys and financial advisors. It can get, a lot of times, if you don't specifically state those powers in the power of attorney in that modification section, they may not, the bank's not going to allow you to do those things. So it's really important. One thing I will mention, though, is that there is a portion of the power of attorney where you can indicate whether the agent has authority to gift to themselves. When I say gift, I also mean transfer money. It's the same thing. So yes, it's important to make sure there's unlimited gifting, as I see it, so that your agent is able to do whatever they need on your behalf. But if maybe your agent under your power of attorney is your spouse, but then you don't have any children, and your successor agent is a remote cousin, and you're not really close with the cousin. You do trust them, but you don't want to give the cousin the power to give money to themselves. They can move money, they can pay for things for your benefit or for your spouse's benefit or whatever it is, but you don't want them to have the ability to give money to yourself. That would be something that you'd want to customize. Or if you own a business, there may be specific powers that you want to include in your power of attorney about, related to the ownership of that business and the running of that business. If you have a lot of money and you need to do estate tax planning, the ability to create disclaimer trusts for your spouse, or other estate tax planning vehicles. And very important, the ability to create irrevocable trusts and revocable trusts, and do what's needed if you ever needed Medicaid or long-term care planning. It's all very important to make sure that it includes those powers, even if you never use them.
Very good. So thank you for that answer. Like you said, you can discuss those all day.
I
So
can discuss it all day.
that's great. I was like, wow, new stuff. That's terrific. So very good. So I guess at this point we have a few people here, and I want to open it up for questions. If there are any questions, I know everyone who's attending who is not Stella or myself, we have muted, but please feel free to hop in. Ray, I see you have a question.
Yeah, I have a couple of questions. First of all, thank you, Russell and Ms. King, for this seminar. digital wallets are very popular now. What's your opinion on putting your stuff in a digital wallet in addition to a regular safe deposit box or your own safe?
Hmm.
And give your agent the approval for the digital wallet?
Interesting. Well, I will say that whenever anybody says safe deposit box, I think about the bank, and I think about, we never recommend keeping your estate planning documents, power of attorney, or um, wills in a safe deposit box at the bank, because if you ever became incapacitated, you'd have to petition a court to be able to access that safe deposit box. So I would say a safe place in your home or in your attorney's office is a good place for it. In terms of the digital wallet, honestly, I don't know enough about it. I think it is important for you to share that information with somebody that in case something were to happen to you, if you have a lot of assets in that digital wallet. But at the same time, you don't want to get hacked. You don't want it shared with too many people. You want to keep it protected. So I don't know if that really answers your question, but it's always kind of walking that fine line.
Well, it's more than just Google Drive. They have
Mhm.
now, they, for a monthly fee, even AARP sells digital wallets, which are totally
Uh-huh.
secure, and they're promoting them very, very, proportionally.
So
I
what,
don't,
so,
yeah.
go ahead, Stella, please.
Oh, sorry. I don't know enough about it. I think it's a great question, and it's something that I'd actually like to learn more about.
If
So
I have
Ray,
two
I was going to ask you, what were you thinking about what would go in said digital wallet?
Oh, I started everything in there already. My bank account information, my lawyer's information, your information,
Sure.
a
So it's
doctor's
just it's
information.
the information as to who to reach out to.
Yeah.
It's not like you're putting in like the will or the power of attorney in and of itself, right?
Well,
If you're not putting
the will is in there, the trust is going to be in there, it's all digitalized, plus you have the actual paper. So
and go ahead.
I'm just saying it's all in there, and it will be all in there once I
And
read
Ray,
the.
I also have a digital, I don't want to call it a digital wallet, but also have a kind of a vault for those kinds of
Right.
documents.
Yeah.
So I have a digital vault as well for those kinds of documents. So if, someone were to, leave those with me, and then someone else were to call and say, hey, this person has passed, I at least have a copy of the documents so that we can move those on. Or even if they don't want me to, like, I could have the document, even if the person does not want to put the agent, have the power of attorney document specifically entered so the agent has authority. But I could hold a digital copy of the document as well. So yeah.
I have two other questions, unless somebody else was something.
Anyone else have other questions? Ray's willing to cede the floor for the moment.
Does
Hang on, Colleen, I think has one, and then we'll come back to you. Right? Colleen, you had a question?
Yeah, I just was hoping, could you repeat how to safeguard against that abuse of POA? Like you had said, it's better to have that POA active. And then you said that you have the document at your attorney's.
Well, for example, if we have a client that, appoints their daughter as their agent under their power of attorney. So they can take the original power of attorney home with them, or have their daughter store it for them. It's up to them. They could do that. But another option is they could keep the power of attorney at our office. The daughter would have already signed the power of attorney, so it's active, but we would not ever give the power of attorney document to the daughter unless we received the permission of our client, the principal, or the client the client's daughter provided us with a letter from her mother's doctor stating that she's not able to handle her financial affairs. So I mean, it's a way that the power of attorney is active. It's ready to be used whenever needed. ready to go, already signed, notarized, everything by both the principal and the agent, but it's not actually in the daughter's possession.
Got it. Okay, thank you.
Sure.
David, Lisa, if you have a question, I'll hop in. You hop in. Otherwise, I'll give the floor back to Ray. Ray, go ahead.
Okay, thank you. I have property in 2 states. I live in 2 states, Jersey, New York. Does the POA be, throughout the country, or you have to have 2 separate by states?
Well, a power of attorney, it's valid even if it's in a different state. If it's a valid power of attorney in the state in which it was created. But laws in different states are different. So if you do move out of state, I would say it's probably a good idea to, or if you have property in other states, it may be a good idea to consult with an attorney in both states as to, whether there's any issues with your power of attorney.
And so I think, right, like the question really is, let's say you're a bi-coastal person,
Mhm.
right? In the sense of, I mean, should it matter as to what your legal state of residence is when you have it signed, right? Because if you think about the following, well, let's just say someone moves from New York to Florida, they're really advised to get their paperwork redone, right? But if someone's like bi-coastal, is that quite the same? Obviously we're talking New York, New Jersey. We're not dealing with bi-coastal kind of things here, but I guess that's kind of the question. Am I getting that right, Ray?
Mhm.
Well, I mean, there's, even if you're bi-coastal, there's still some place that is listed on your tax return where you file taxes. There's still something that's on your driver's license. There's still, where you're actually a resident. So that's one thing. But the other thing is that, yeah, I mean, you can be bi-coastal. You can have a New York power of attorney, but then also, spend most or a lot of your time in Florida. But I do think it would be important to that, if that were the case, to maybe have your New York power of attorney reviewed by somebody who practices in Florida to see if there's anything specific that should be included in the power of attorney for Florida law. For example, there's I believe I am not admitted to practice in Florida, but I have heard that, you need to actually specify the address of the property that you own in Florida if you want your agent under your power of attorney to be able to transfer it. Again, I don't practice in Florida. This is not legal advice, but I'm just saying that if that is correct, that would be a difference from New York, and that would be, something important to know and to consider.
Mhm.
Very good. Lisa, I think you had a question. You are muted, Lisa. I know Lisa's
Apologies
in
for the background noise on the train. Can you guys hear me or no?
Yes, we have you.
Hi, Lisa.
Okay. Um, I know both of you well, and you're both far more diplomatic than I am. So, any tips on starting the conversation with parents or grandparents who are really reluctant to even start talking about a POA?
Yeah, it's tough. I mean, it's you can lead a horse, right? But I think that explaining to your parent or your loved one that, why it's important, that ultimately, again, it actually gives them more ownership and decision-making power about what happens to them, because if you don't do this, or if you don't do it correctly, then it could be that somebody who ends up getting that power, it's not the person that you would want to be in charge. It's not the person that you would trust. It can end up being, very expensive and difficult. Again, I've talked about the alternatives like guardianship. So it's, the hope is that never happens, but you just don't know. So it's really important not to wait until disaster strikes, to take the steps now to, figure out who you want to be in charge and make sure that they're aware of what your wishes are and what their responsibilities would be and where your important documents are. Because you just don't know what can happen.
From my perspective is really right. If you're speaking with someone like that, the question is whether or not they have a will and it's been checked. Because once you have that done, the power of attorney is going to follow on. Any attorney worth their salt is going to make that part of the package.
I would agree
So-
with that.
So there, you know, if you're getting a will done, you're going to have a power of attorney done at the same time. And so if they don't have it, you know, it's time, hey, when have you reviewed your will? What's going on? What do we need to check on and change? And have that done. That would be my answer. Okay, any other questions? All right.
I got
That being,
I got one
go
more.
ahead. Go ahead,
Uh,
Ray, we're with you.
Stella mentioned about revocable trust. Is that do they supersede a POA?
So it can. So essentially, you know, a revocable trust, it's like it's a bucket. So it's, you know, an empty vessel that you put assets into. You can put your real property into it. You can put bank accounts into it. So whatever property, whatever assets are retitled in the name of the trust are subject to the terms of the trust. So yeah, the power, they would be outside of the scope of the power of attorney because they're in the trust. That said, you know, a power of attorney can give somebody the ability to create a revocable trust. And a power of attorney would be appropriate for assets that are not titled to a trust. I do like the revocable trust because, you know, I mean, we always do a power of attorney no matter what. That's, you know, 100%. But a trust does, you know, for example, power of attorney, what a lot of people don't realize is power of attorney expires on your passing. Once you pass away, your power of attorney, it's meaningless. It's nothing. So if somebody's on your bank account as a power of attorney, when you pass away, that's it. There's no, you know, they can't access it. It's a probate asset. But if your asset is titled to a revocable trust, let's say, not only would your successor trustee have the ability to, you know, jump in, manage your affairs, your accounts, whatever it is, pay your bill if something happened to you during your lifetime, but upon your death, the assets in the trust pass according to the terms of the trust, and it avoids probate. So it's, I mean, I like them, but
Yeah,
I'm also a trust and estates attorney.
right. And just from a high level, Ray, in my experience, right? And that's always been the question. Like I've had quite people who have said, you know, right, how do you pay a bill for someone who just passed? Right? If they've passed and they don't have a trust, you can't. And so now you just have to go through the probate process and deal with that. And some people have more complex things than not. So obviously your level of, you know, one's level of complexity determines whether or not that's necessary. But right, and that's the issue. And so
And
you know,
also,
yeah.
also with the power of attorney, I mean, if you have a lot of assets, a lot of bank accounts, you would have to take that power of attorney to each of those financial institutions, you know, have it processed through their legal department, make sure it's valid, all of that, you know, a bunch of different times. Whereas, yeah, it may cost more to do a trust, and it may be a pain to retitle your assets in the name of the trust. But if you then, once you've done that and everything is under, or a lot is under that umbrella, it's a lot easier for someone to step in more quickly.
Thank you.
Give the rest of the floor a question, an opportunity, then Ray another opportunity to ask yet another question if he has one, and then we'll close. Lisa, looks like you're jumping in.
Yeah. For someone who thinks they will probably be doing some Medicaid planning, anything that would be different or anything they should start thinking about a little bit earlier?
Yeah, I would definitely say, you know, you want to make sure your power of attorney has broad gifting powers, because if those aren't included in your power of attorney, or then your agent wouldn't have the ability to move assets out of your name in order to get you on Medicaid. We see that issue quite often, or the ability to create an irrevocable Medicaid asset protection trust. You need that explicit ability within your power of attorney in order for your agent to do it. So it really, is very important, yes, to have a power of attorney, but making sure that your power of attorney covers all of these things depending, on your situation. It's a way that you're protecting your assets.
Very good. Anyone else? Okay, very good. Thank you. Stella, how can people contact you if they want to have more specific
Yeah,
questions or
feel
consult?
free to reach out. You can either call the office at 914-948-1500. Again, 914-948-1500, and ask for me, Stella King. You can also email me at s.king, King, at esslawfirm.com. Yeah, I can also put my information in the chat if you like.
We don't have it. We don't have a chat, so
Oh,
we don't have
okay.
a chat on this. Yeah.
Or just
No,
ask
I
Roy.
have. Yeah, ask me. And for me, I'm Russell Rivera. I know everyone on here live with me knows me and knows how to reach me. But if you're catching us later and you'd like to see us, Russell.Rivera, RUSSELL.Rivera, RIVERA, like Mariano at voicewealth.com. I know you appreciated that one, Ray. And phone number is 631-361-9000. So you can reach me there as well. So thank you to everyone who joined us today. Thank you to Stella for giving us an hour plus of her time in prepping and doing this. We are going to have another one next month in January. This one's going to be with Jerry Elena of Mill River Plans, talking about businesses starting a retirement plan. So that's on January 15th at 3:00. So if anybody knows anybody who's, a small business owner or something like that would like to kind of figure out the retirement plan landscape for 2026 and whether or not they should start one and how they can do that, Jerry will be here. We'll be talking about that. So thank you very much to everyone.